Hello. Hi, everyone. Welcome to the Disability Law Q&A session, which is a live stream session with me, Martin Willemse. I am a lawyer and partner at the firm of Samfiru, Tumarkin, and the Western Canada practice leader with respect to disability claims, all things disability. Our firm services clients throughout Canada other than Quebec. We've got offices in BC, Alberta, and Ontario. So when we have this session, I welcome all questions my way. You can post your questions, send in your questions, and I'll read through them and respond to them as best as I can. So while we wait for some questions to come in, I'll speak about some issues with respect to claims on disability. Again, you can ask us your disability and insurance law questions now, send them in, and I'll read them as they come up. What are some common reasons for disability claims to be denied or suspended? We speak about this on our radio show and our TV show regularly. One of the reasons why claims are denied is often when it is what is called an invisible illness. Things like chronic fatigue syndrome or myalgic encephalomyelitis, which is the other word for it, fibromyalgia, chronic pain when there is no objective evidence, if you want to call it that. In other words, you cannot see it on an MRI, a CT scan, or an X-ray, and in many, many cases, mental health illnesses like depression, anxiety, PTSD, bipolar disorder, etc. I'm often asked, what is the best way to submit evidence? What evidence can I submit to ensure that I have the best opportunity to have my claim approved? And the response would always be, speak to your doctor. Have your doctor on board if you do want to submit a claim. If you find that you cannot work, if you are disabled, in other words, that you have restrictions and limitations that would prevent you from engaging in your occupation, in other words, from performing the essential duties of your occupation, speak to your doctor, see your doctor regularly. And when your doctor completes the paperwork, there are a few things that you have to submit. The first one is your claimant statement. The other one would be a sponsor statement, which would be something completed by the employer. And the third one is called an attending physician statement. That document is extremely important. So when you submit your claim, you have a discussion with your doctor, see if your doctor supports that you stop working. In some instances, doctors actually suggest and recommend that their patients stop working. Give the form to your doctor and then have a discussion with your doctor when the form is being completed. I see lots of cases where a doctor may say, my patient is unable to work because they have depression. Your claim is going to be denied. If it is, my patient is unable to work because of anxiety, depression, PTSD, and the doctor doesn't give any further details, the claim is going to be denied. The reason for this is the diagnosis is important. Yes, it is. But a disability claim, when it is based on a contract, the person making the claim, which in other words would be you, the patient or the insured or the claimant, you have the duty to prove why it is that you cannot work. Not that you just have a diagnosis, but why, as a result of that diagnosis, you cannot perform your duties. For example, if you said that you have depression, your doctor says you have depression, your doctor agrees and recommends that you stop working, the doctor should, and you should as well, advise the insurance company why it is that you cannot work. And here we get to look at what is called functional restrictions and limitations. The doctor has to detail what are the functional restrictions and limitations. In other words, with depression, you would get, and I'm just using this in general because these are generally the things that you see, lack of focus, lack of concentration or poor focus, poor concentration, inability to comprehend information, inability to multitask, poor sleep, low mood, fatigue, low energy, poor motivation, cannot deal with others, cannot deal with any social contexts. Those are reasons why a person may not be able to work, and then translate how that would impact your actual duties. In other words, if you work with the public as a bank teller and you have depression, you cannot focus, cannot concentrate. Obviously, those things are key to performing those duties. It has to form a picture. This is the diagnosis. These are the restrictions and limitations. In other words, these are the reasons the person cannot work. And then correlate them back to why can the person not perform the duties when you're looking at these restrictions and limitations. If you have the doctor complete a form like that and you submit your information as well, dealing with it and describing it in that way, you should enhance your chances of getting your claim approved. Of course, if it is not approved, you have the option to appeal, or you can litigate, depending on your circumstances. When it is denied, I highly recommend that you reach out to a disability lawyer who can give you an informed opinion as to what your options are. And that, of course, is what we do. So go to disabilityrights.ca or contact us at one of our offices. We have an online question from Arthur. My insurance policy limits my ability to travel, but I have to leave the country for a family emergency. What should I do so that my insurance isn't cut off? It depends on what the policy says. So some policies may provide that the person cannot leave the country for more than 30 days. Others may say more than 60 days, others say more than 90 days. I would be surprised if the policy said the person cannot leave at all. So it depends on the timeline as to how long you will be traveling. If it is a family emergency, I think be upfront with the insurance company and tell them, this is what I need to do. Maybe have a letter by the doctor as well advising that you can travel. And when you do travel, make sure that you report to your doctor an ongoing report of restrictions and limitations. Make sure that you continue to engage in your treatment. If you're going to be away for a period of time, make sure that you find treatment providers wherever you're going to continue with treatment. If it is a mental health situation, you may be able to engage with online counseling if that's what you're doing. But be upfront. The insurance company should not deny your request on an unreasonable basis. But remember, the fact that you are traveling depends on what your disability is. If it is, I cannot sit for long periods of time, and you're going to be traveling to Europe on a 10-hour flight, there's going to be a question mark as to how are you able to do things like that. So may take more medications, be upfront with the insurer, be upfront with the doctor, get the doctor's treatment recommendations, maybe put that in writing and see how that goes. Then we've got a question on YouTube from First Time Grow. I'm on LTD going on 2 years now. My work insurance provider pays half and CPP pays the other half of my wages. But they sent me papers last month, and on one of them, it said after 2 years, they might or will cancel or change life insurance policy that is included in my work insurance. My question is, can they do this? I'm not sure if this is referring to waiver of premiums, because some policies may have two benefits. The one is called a waiver of premium benefit, and that relates to other coverages like life insurance, and others may just be on life insurance itself. So if your coverage is in place, in other words, you've got your long-term disability, it is being paid, and you've got a waiver of premium option, that should continue as long as your LTD is approved. If it relates to other coverages, it may be if your employer is going to say, well, we're going to terminate your employment now, that you may lose those coverages. So I think in this situation, it's not 100% clear to me as to what coverage may be lost. So again, I would suggest here that you reach out to us so we can have a look at what the policy provides and what exactly the letter says that they had sent you. Because I don't think you would just lose life insurance. It may relate to premiums, but that should not, if you've got a waiver of premium benefit, that should continue to be waived as long as you're accepted for LTD. So highly recommend you reach out to us so we can at least look at your situation and have a better understanding as to what the question is, and then we can advise you on your options. We've got a question on YouTube from Missy. Why does my insurer need my denial letter from CPPD? Should I provide this to them? The reason why insurance companies are very interested in CPP disability benefits in the first instance is the vast majority of group policies, basically all of them, will provide that CPP disability benefits are offset from LTD benefits. What that means is, if you get $3,000 from your long-term disability provider, you apply for CPP disability, and it's approved and you get $1,000 there, then your LTD provider only has to pay you $2,000. So they're very interested in the CPP disability application. They may want to see why the claim was denied by Service Canada and may want to have you appeal it. So if you refuse to give it to them, I think there may be an issue there. You may want to appeal that decision in any event. Remember, there's a specific timeline within which you can appeal. So look at what that timeline is, consider whether you're going to do it. Because if you refuse to do that, the insurance company may say, well, we wanted you to appeal, you didn't, so there's a breach there. Again, in your situation, I would also suggest that you speak to us. Maybe just have a look at the policy. But in general, insurance companies do expect you to apply for CPP disability benefits. And if it is denied, you may want to appeal it. We've got a question from BA on YouTube. My doctor has referred me to a specialist and has advised that I cannot return to work until I finish this treatment. I'm in the process of applying for long-term disability, but my employer has said that if I do not return, that they will consider this a resignation. If they claim I have resigned, am I still able to pursue disability? If you are in the process of applying for long-term disability, it probably means that you haven't been away from work that long. So in your situation, please reach out to our firm and speak to one of our employment lawyers, because your employer should not be taking this position. If your doctor supports that you are unable to work because of a disability and you are actively engaged in treatment, now seeing a specialist as well, your employer should not be terminating your employment and definitely should not be seeing your failure, not your failure, your inability to return as a resignation. That is not correct. You should have a discussion with one of our employment lawyers to at least advise you on your rights. Go to www.employmentlawyers.ca where you can get some information on this. Going to the other part of the question. Sorry, just need to move down and go see what it was. If they claim I have resigned, am I still able to pursue disability? Yes, you can, because as long as your disability vested when you had coverage, in other words, when you were still employed and you had coverage under the policy, you can still apply, even if you lose your employment. There's no reason why you should not, because your claim vested when you have coverage and it's an ongoing disability. Unless it is due to some other reason that you've been away from work for a period of time, not due to a disability, and then want to apply, because there are certain contractual provisions that apply that may prevent you from applying for a benefit because you may have lost coverage. But in your situation, it seriously doesn't sound like that's the case. Sorry, Sam Lupin says, what is considered a pre-existing condition? My sister's insurer has been saying this to her, but she doesn't understand. This is a good question. And other than just say, reach out to us and maybe we'll have a discussion with you about that, what that means, I am going to say that. But I'll give you some background as to why I'm saying that. A pre-existing condition in everyday terms means it's something that you've had before. But in a disability contract, remember what we're dealing with is a contract. That policy is a contract. Pre-existing condition will be a defined term. What that means is, if you go off work, if your sister went off work within the first year of having coverage, which it sounds like, then the insurance company can investigate whether her disability is related to something that directly or indirectly, a sickness or an illness or an injury that existed during a specific period of time. So it is a very, very fact-specific analysis. And I have seen various cases where insurance companies made the wrong decision in denying the claim when the condition clearly was not a pre-existing condition within the meaning of the policy. Yes, the person may have had, for example, if I speak about depression, the person may have had depression for a long period of time, but that's not the issue. The issue is, did they receive treatment during a specific period of time to qualify it as a pre-existing condition? When an insurance company relies on the pre-existing condition exclusion in the policy, they have the duty to prove that, in fact, it is a pre-existing condition, which would then prevent the claim from being paid. So they have that duty. I review pre-existing condition cases on a weekly basis, and I would say at a big amount of those, there is an arguable claim that the condition is not a pre-existing condition within the meaning of the policy. So have your sister reach out to us. We'll look at the letter. We'll look at what the definition for pre-existing condition is, and then we'll look at the facts. Did she receive treatment for an illness or a condition that was directly or indirectly related during a specific period of time, which ultimately related to the disability itself? It may become a bit complex, may sound a little bit complicated, but there are ways to deal with these pre-existing conditions. Of course, there are situations where it clearly was pre-existing, and then we cannot assist, and the insurance company is probably right. But as I said, many of these cases where there is a denial, we can assist because there's a claim to be argued. We've got a question from Melissa Teresa. I've been on LTD since 2017, as well CPP since 2021. I live in a rural area, dead-end road. Unusual vehicles stand out. There have been vehicles outside my home. I suspect insurance has hired surveillance. My neighbor noticed and approached the person inside the SUV. They wouldn't identify themselves. Is it not the law for persons to identify themselves as such when asked? Let me answer the question this way. When you are on claim, in other words, when you're receiving benefits, insurance companies on occasion will hire private investigators to conduct surveillance. Quite often these days they conduct online surveillance, but they also still do surveillance where they may follow a person around, where they may go sit outside their house and surveil them. Obviously, and understandably, people feel very upset about this because it is, to some extent, an intrusion in their lives, because nobody wants somebody they don't know recording them. Is it against the law? It isn't. It depends on how far the surveillance goes. They cannot bug your phone. They cannot come into your house. Can they follow you around? Yes. If you feel threatened, by all means, reach out to your local law enforcement and report that to them, because ultimately you don't know if this is what is happening. But are they supposed to identify themselves when they're approached by someone that they don't know? I don't think that's what the law requires. So unfortunately, insurance companies do surveil people. I've seen it happen a lot. But also consider that online surveillance is becoming a much bigger issue these days. Insurance companies love to do online surveillance of people who've been on claim and may have been on claim for a period of time. For example, they may hire private investigators who may use bots to do online surveillance to see what your activity is on Facebook, Instagram, or other social media platforms, and other types of online surveillance. So to anybody out there listening or watching, if you do have a claim, remember, anything that you post online while you're on claim may be surveilled by the insurance company to see whether what you are reporting to the insurer with respect to your restrictions and limitations is consistent with what you are posting online. For example, if you say you have a bad back and you cannot sit for long periods of time, you cannot walk for long periods of time, you have chronic pain, you need to lie down a lot during the day, otherwise your back pain flares up, but you have pictures of yourself snowboarding or skiing or going on long motorbike rides, you run the risk of the insurance company looking at your claim much closer, because what you are reporting to the insurer may not be consistent with what they see on social media. Now, I have seen cases where people have posted pictures of themselves, but those pictures may have been old. Those pictures may have been taken when the person was not disabled, when they didn't have these restrictions and limitations. Yet the insurance company denied the claim because they would do online surveillance, find that there has been activity which they assume is recent because the pictures were posted recently, and then assume that the person is not forthright with their restrictions and limitations because the activity depicted on the pictures is not consistent with what is being said by the client. So the message, I suppose, is to anyone, even if your claim is denied because there was surveillance and the insurance company relied on that, please reach out to us. A visual is very powerful, but you also see situations where the insurer may have retained an investigator. They had somebody surveilled for 5 days and there's footage for only 3 days. So the question is not just what do we see on surveillance, it is what do we not see on surveillance. If the person was active one day and then they didn't leave the house at all because they were paying for being a little bit more active the day that follows, that is consistent with what they were saying. So don't feel threatened, don't feel hopeless. Reach out to us and we can review your situation by looking at the facts, the denial letter, and the policy. We have a question from Bush on YouTube. I have attended an IME, which is an independent medical examination, and an FCE, which is a functional capacity evaluation. Both of these were a significant amount of trouble and aggravated my condition considerably. My doctor has advised that he does not recommend I attend another, but my insurer is telling me I need to go again. What can I do? Okay, so few things to be said here. Insurance companies rely on certain provisions in a policy that would allow them to have you assessed. You've done an IME, which would have been done by a physician, like a physiatrist, or an orthopedic surgeon in this case. I don't know if that's what happened here, but I'm going to guess that's what happened here. And then a functional capacity evaluation, which is in itself can also be aggravating of a condition. And then there was a lot of travel involved. So insurance companies rely on these provisions where they say they are allowed to assess a person, but it also has to be done on a reasonable basis. So you've already attended 2 of these. Now they want you to attend another one. I find that concerning. I would want to know why they want you to attend another one. Who is it that they want you to see? What were the opinions in the IME and the FCE? Do those opinions support that you remain totally disabled? And if they do, why on earth would the insurance company want you to attend another one? On top of that, the fact that your condition was aggravated by attending these appointments, you've already got the right angle here, because you said, you spoke to your doctor about it. My doctor has advised that he does not recommend I attend another one. That is key here. Have your doctor put in writing why he does not recommend that you attend another one. Speak about the aggravation, because quite often, and this is always a concern, when somebody attends a functional capacity evaluation, that would be sometimes a 1-day process, sometimes a 2-day process. The person is put through various functional tests, things that they don't do regularly because they are on disability, they're not working. So they put forth their best effort. They may be able to do some of these tests, and then they go home. But quite often, the person who conducted that test, the functional capacity, normally an occupational therapist, sometimes a kinesiologist, they don't follow up. In other words, they don't phone the person the next day or the week afterwards to say, hey, how are you feeling now that you did these tests? All they do is they would look at it and say, we've had a look at the test results. We believe that this person is capable of doing these things because during the testing, they may have been able to do so. But that's not necessarily the consideration for disability. You need to know whether the person can consistently do these things. And by doing that, did they suffer? Did they suffer a relapse? Did they suffer an exacerbation of their condition, their injury, their illness? These are things that we see on a regular basis when cases get denied. So the insurance companies may get these reports, then rely on these reports, which they pay for. So they go out, they hire an independent medical examiner or a person to do the FCE. They pay for them, and they're expensive. Then they get an opinion that they then rely on, that the person is no longer disabled. They deny the claim. And then the person who was making the claim looks at the denial letter and says, okay, well, they're relying on these doctors' reports or these expert reports. Clearly, they must be experts. So maybe they're right. They're not. If you find that your condition was exacerbated, or that your condition worsened, or that you suffered a flare-up, and if your doctor continues to support that you're unable to work, you probably are still entitled to benefits. Remember, when the insurance company does things like that, when we get involved in cases, we can do exactly the same thing. We can also send you for an independent medical examination or an FCE if the circumstances require it, which I think quite often they don't, but that's just my opinion. You want to make sure that your doctors are on board and that you have proper evidence to support that you remain disabled. And in this case, if the insurance company is insisting that you go and attend another assessment, like I said, have the doctor put in writing why it is advisable not to do so because of the aggravation. You send that to the insurer, and if they still insist you go, reach out to us because we'll discuss your options with you. We have an email question from Benita. My insurer has recently begun requesting things directly from my doctor. Should I be concerned about this? Shouldn't they have go through me first? Well, the reason why they probably are doing that is you may have signed a authorization allowing the insurance company to request things directly from your doctor. If you did not provide an authorization or a consent, this is a big concern because they shouldn't be approaching your doctor without your consent. So I think in this case you likely did sign one, but if you didn't, again, reach out to us and maybe tell your doctor not to communicate with them if there is no consent in place. Question on Facebook from Sarah. I suffered from juvenile arthritis. It left me with some limitations, but I was mostly able to work a normal job. Recently, I've had a flare-up of arthritis that have left me incapable of doing much. I applied for LTD, but the insurer is saying that this was a pre-existing condition. Is there anything I can do? This relates to the earlier question that I answered. Pre-existing conditions are contractually defined. In other words, the term pre-existing condition is a contractual term. I will use a brief example. A pre-existing condition may say that if you go off work within the first year of having coverage, which Sarah, I think you probably did, because that's the only time that they consider whether it is a pre-existing condition. If you go off work within the first year of having coverage, they're going to look at whether you had treatment for a condition that is directly or indirectly related to your disability during a specific period of time. You did have juvenile arthritis. It left you with some limitations. So I assume that they will say that during a defined period of time, you continue to have treatment for that, be it whether you took medication or whether you consulted with a doctor. So again, it is extremely fact specific. We would want to know what is the definition for pre-existing. The timeline, for example, may be the 3 months before you had coverage. If during that specific time you had treatment, which is another defined term. In other words, you were seeing a doctor, you were consulting a doctor, or you were taking prescription medication. If that happened during that time, your claim may be excluded. If it didn't happen, or if it happened or if you saw the doctor for something else during that period of time, it may not be pre-existing. So we would want to look at the specific timeline that they're looking at, the factual pattern here. What did you see the doctor for? In other words, looking at the clinical records, and then looking at the denial letter. So don't just assume that they're correct. Have a disability lawyer review the contract, review the letter and the facts, and we can give you an informed opinion. Oh, it's the same question. Flare-up of arthritis. So if you have any question that has not been answered today, if there are any other questions that you may have, or if you have a denial, or if you have a family member who has been denied disability benefits, or critical illness benefits, or life insurance benefits, or travel insurance benefits, please reach out to us. Go to disabilityrights.ca. We have lawyers, as I said, not just me. There's a bunch of us who handle disability law who can review your claim, and we do this on a free basis. So we offer free consultations to review the documents and, most importantly, to provide you with an informed opinion. I have many people who reach out to us, and then at the end, we may not be able to assist, but just having some clarity. When you're working through this dark tunnel and you don't know what you're dealing with, because insurance companies have the policies, they know why they are doing what they're doing. The person on the other end is just making a claim, suffering financially because they're not being paid, and then also dealing with an illness. So the financial stress on top of the other stress of not being able to work and struggling with a health condition can be overwhelming. You want somebody who could do this for you. Look at the denial, look at the policy, look at the clinical records, and speak to you about what your options are, which may include an appeal, but also litigation. Remember, when you appeal denial, you're appealing it to the same entity that denied your claim. You have no leverage. You're literally just asking the same entity to review their opinion again by providing further evidence. And quite often, doing the appeal, the insurer would say to you, it's your job and it's your financial burden now to go and get more records, maybe letters from the doctor, which you then send to the insurance company, and then they just reconsider their own decision. Whereas when you get involved with a lawsuit, in other words, with a legal claim, which we represent people with, you're no longer dealing with the insurance company. We are dealing with the insurance company. All communications go through us, and you can focus on your treatment and try to get better while we try and get you the proper compensation that you're entitled to. And we work also on a compensation basis, which is if there is no resolution, there is no fee. So it's a contingency fee. Any questions regarding that, you're welcome to reach out to us. As I said, we've got offices in BC, Alberta, and Ontario, and we represent clients throughout Canada other than Quebec. Go to disabilityrights.ca, which is now reflected on the screen, and you can also listen to our radio shows and our TV shows, and our website has a vast wealth of information. So our next session will be on Thursday, May the 4th at 12 p.m. Eastern Standard Time. And that will be an employment and disability law Q&A with Alex Lucifero, one of our partners. So thank you again for attending, and I look forward to seeing you next time. Have a great day.